Welcome. I'm Ada Kay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Welcome and good evening. I hope y'all had a fabulous Monday, a new start to a new week. I did. I ended up being in Austin, Texas for the day. Yay. Not really. No, it wasn't that bad. I had hoped to go see our fabulous mod, Angela, who recently has just been recovering from surgery, but unfortunately it did not happen. She is not feeling very well today. She had a particularly rough day, so y'all keep her in her prayers. Today, oh my gosh, y'all, Jose Soto-Escalera Spencer hearing, the pregnant mistress murder trial, was in court again. Again, he was in court, and this time it was for his going towards his sentencing phase. Now, when it comes to sentencing, Florida laws recognizes two types of mitigation: statutory and non-statutory. Statutory mitigation covers things like extreme mental disturbance, situations of extreme duress, the minor participation in a crime. These are factors explicitly outlined in the law. Then there's the non-statutory mitigation, such as often called the kitchen sink. This is where you find everything else. You might humanitize a defendant or lessen their moral culpability. Childhood beatings, fetal alcohol spectrum syndrome disorder, low IQ scores, military services, you name it, it is in this part of it. It is anything that can put a filter on what happened and more complex picture of the person standing before the court. Defense counsel in this hearing signaled that they would front load three main themes: chronic trauma, organic brain damage, and what they call residual good. Yep. I got to get that up. I'm sorry. Oh, there it is. Welcome. Take it to trial. We have a new member. Oh, yay. Thank you so much for joining us. There, I can hear it now. There it goes. We appreciate you joining our team. We appreciate you being here. You are amazing, and thank you so much for becoming a member. We do have memberships. They start off at 99 cents, so anybody can afford it. 99 cents a month, and it helps us support our channel. Welcome, welcome, love. We are so grateful to have you here with us, and I appreciate your willingness to support this channel. All right. So let's dive in. I've got a lot I want to share with you. I have researched. I have a lot to give you. And then we're going to watch or speed watch the hearing itself. So Dr. Deborah Motado, a forensic psychologist, took the stand and meticulously walked the court through 189 pages of Department of Children and Families records. Yes, you heard that right. These files started when Jose was just 2 years old. We're talking about things from severe malnourishment to broken femur at the age of 4, to being locked in the closet for 24-hour stretches, actual assault by a cousin, and tender age of 9, the horrific catalog of abuse. She then tied these traumatic events directly to MRI findings. Yes, you heard that right. They MRI'd his brain. Why? They wanted to look at the gray matter, and yes, it is being reduced. They found reduced gray matter volume in Jose's frontal cortex and critical region of the brain tied to impulse control and decision making. Literally, this slots neatly under the extreme mental or emotional disturbance. Yes, you heard that right. You heard it right. That is what they're looking at. Yep. This was not brought up in trial. The jury did not hear any of this. The prosecution, of course, is countering. They argue that these scans don't prove that he couldn't premeditate. They might just prove that he premeditated poorly. And that's the key distinction here. The statute isn't about excusing the crime. It's about lessening the moral culpability of the crime. Judge rarely treats this factor alone and weighs enough to sway the sentence, but stacked with other mitigators, it could absolutely tip the scales. The next person that got up was Dr. Alan Tesmer, neuropsychologist, who administered a full battery of psychological testing. The WAIS-4, the Trails B, the Wisconsin card short, the Soto-Escalera scored a whopping 72 IQ on a verbal comprehension, which puts him squarely in the borderline impaired range. Okay. But even more importantly, tested relevant significance deflects in got it. I'm sorry, I got a gnat floating around and it's distracting. Executive functioning, that is the part of your brain responsible for the planning, flexibility, consequential thinking. Dr. Tesmer testified that this profile aligns perfectly with an individual who tends to act explosively, driven by impulse rather than with calculated cool intent. The prosecution, however, on cross-examination rarely harped on the fact that Jose wiped down the shell casings, poured bleach over the body. Would somebody with a 72 IQ do that? That's premeditation. That's planned. What are your thoughts on that? To me, that doesn't fit. I'm seeing this instead of seeing this. Dr. Tesler conceded that there was some planning, but he argued it was rudimentary at best, almost childlike. Describing it like child hiding his cookies? I think not. I tend to disagree with us. If I was on the jury, I would not be accepting his testimony. But that's my personal opinion. What is yours? So Judge Kemp has a tough decision here. Does the low intellectual function combined with a history of trauma create a perfect storm that lessens the culpability, or is it a rudimentary planning, still planning enough to justify the ultimate penalty? Perhaps one of the most gut-wrenching moments came with the live testimony from Marisol Soto, Jose's mother. She described losing her own mother at the age of 7, entering into foster care, and then later tragically abusing meth while pregnant with Jose. She swept the audience with her emotionals and her cracking voice, choked with emotion, saying, "I baked a broken baby. If you spare him, he can teach other broken kids not to become him." Doubtful. Emotional. Absolutely. Legally, it falls under the non-statutory mitigation, but it personalizes the generational cycle of arguments as why statistics never could. Florida courts have, in the past, accepted family circumstances as a powerful mitigation, even when the jury may have rejected initially. From the prosecution, in turn, reminds the courts that Tania Wise family also suffers from a new generational trauma. Now, an unborn grandchild who never took a breath. Balancing these components compounds the sorrow. Thus, profound human tragedies is unspoken, incredibly difficult task Judge Kemp now has. The defense also tried to present the glimmer of a different Jose, sliding the certificates from his brief Army stint. He's a sharpshooter badge, an honorable discharge. Okay, so that can make him a sharpshooting red rumor. Just saying. They even produced testimony from the Hillsborough jail inmates who claimed Jones intervened during a gang beating, resulting in stitches over his eye. Oh, he broke up a fight. Good for him. Some people with an IQ of 72 wouldn't be able to do that. Just saying. It was an attempt to show some residual good. Residual good, mitigating circumstance. The prosecution, however, quickly argued that the military training actually demonstrates discipline and capability with firearms. He's capable. If he was that with the mentality of a 72 borderline, then how in the world could he have done this? The two don't match. We're getting this. We want this. And in their view, is aggravating, not mitigating. It shows he knew how to use weapons effectively. The judge then has to weigh whether any of this residual good is truly sincere, a sign of inherent characters, or merely calculated attempt for the jailhouse reputation management. I need to check something because I'm not getting any comments here. And I need to go in and double check and make sure that everything is set to where it needs to be. For some reason, I normally have comments. I don't have any comments. Give me a minute. I'm going to go to my dashboard. I need to make sure everything is fine. I normally don't do lives this time of night, so it's a possibility that I just don't have a lot of people on. Customize. Okay, so we're all good. All right. Miss June. Okay, thank you very much, Miss June. It was kind of worrying me because I'm not getting any comments. So Dr. Deborah Montalgo, forensic scientist, took the stand and meticulously walked through these pages. We got through all of that. We got through, I lost my skill. Okay. So now we're at the assistant state attorney, Jane Young, closed her arguments with a powerful PowerPoint presentation, starkly titled Justice for Two. She meticulously highlighted the jury's unanimous findings: cold, calculated, premeditated homicide committed specifically to avoid a paternity test, and then especially heinous, atrocious, and cruel nature of the shooting of a pregnant victim in the abdomen. She even replayed the medical examiner's chilling description of the fetus's skull piercing. Under Florida law, heinous, atrocious, or cruel, HAC, is a legitimate aggravator. Oh, thank you guys for hopping in and liking. Hello, hello, Teresa. Providing a victim was conscious and suffered needless trauma. By the way, a baby at that age would suffer. Yeah. I don't care if it's in the womb. It has pain receptors early on. The judge can adapt those jury findings wholesale. They don't need independent corroboration today. The prosecution's message was clear. The brutality of the crime, the double loss, demanded the DP. Almost said it. Hello, thank you for joining. Then came the victim's impact statement. Tania's mother, Pamela Wise, took the stand, clutching an ultrasound photo of a broken-hearted symbol of what was lost. She spoke directly to Jose, her voice raw with grief and accusation. You punished her for giving you life. Florida law does allow victim impact evidence at a Spencer hearing. However, there's critical caveat. It must not be so inflammatory that it encourages a verdict based on purely an emotional rather than evidence. The defense predictably moved to strike the portions referring to burn in hell argument crossed the line, but the judge overruled, calling it brief and non-prejudicial. Appellate courts historically routinely affirm a few fiery sentences, while emotional does not outweigh constitutional right of the victim to be heard in their own words. It is a delicate dance and a balance between allowing grief and perceiving undue prejudiced. So let's tidy up and tally up the legal scoreboard as it stands. For statutory mitigators, we have 1 extreme mental disturbance and 2 substantially impaired capability to appreciate criminology. On the non-statutory side, the defense presented a child abuse, low IQ, military service, alleged good deeds, and a significant family circumstances. Now, for the aggravators, which are often numerous in these cases, 1, prior violence and a felony, 2016 robbery, 2, red room to thwart witness, 3, victim being pregnant, and 4, heinous, atrocious, cruel nature, the HAC, or HAC Act. Numerically, it might feel lopsided right now, like the aggravators are winning. But here's one thing about Florida law: it doesn't tally these factors like a baseball card. 1 powerful, compelling mitigator can, if the judge finds significantly persuasive enough, outweigh multiple aggravators. It's about quality and weight, not quantity. The Judge Kemp now has 3 lawful choices, and it's critical that we understand them. He can impose the DP. He can impose life without the possibility of parole, or theoretically, he could depart downward and life with the possibility of parole. Though, let's be honest, that last option is particularly off the table in most people's mind, and in capital red room cases today, most likely will not happen. Case law dictates that the written order he issues must include specific findings on each proposed mitigator. He has to explain why any rejected ones lacked credibility or sufficient weight is given. This isn't just a bureaucratic paperwork. Appellate reviews, especially from the Supreme Court of Florida, will scrutinize whether these findings are supported by competent, substantial evidence. Translation: the judge must write an airtight order, methodically detailing his reasoning, or the Supreme Court will kick it right back for resentencing. And trust me, that's not something the victim's family wants to go through again. So let's talk about the statistic, because they often paint a stark picture. Florida judges now follow a jury of 12-0 for DP recommendation over 85% of the time. However, that law has changed. The rare reversals, when they happen, usually stem from procedural errors, not from the judge simply sustaining a life sentence for a DP sentence. The last time Florida judge actually overruled a unanimous jury recommendation for DP to be imposed life was way back in 2016. And that case involved a defendant who intellectually disabled, a condition Soto-Escalera has not alleged here. So bottom line, while the Spencer hearing is legally vital, the critical safeguard, strategically speaking, it is an incredibly uphill battle for the defense. The odds are in the favor of the state. So here's the question for you. If you were the judge, and I want your answers down below, if you were the judge, which factor would weigh the heaviest in your mind? The childhood torture and the brain damage, or the sheer brutality against the pregnant victim? Which would stick out more in your mind? Drop your vote in the comments below. I actually want to see your post and your vote, and I want to talk about it. So, if Judge Kemp does impose the DP, legal battle is far from over. Soto-Escalera will have 30 days to note direct appeal to Florida Supreme Court. You can expect the claim, kind of like the judge erred in rejecting certain material of mental health mitigators, or 2, the victim's impact statements exceeded constitutional limits, or 3, cumulative error, meaning that all the small little errors that were made in the trial add up to an unfair process. DP appeals, you might imagine the evidential death warrant after the state and federal habeas corpus appeals are fully exhausted. The whole process from beginning to end really highlights the ethical tension in our justice system. Defense attorneys, by oath, swear to provide zealous advocacy for their clients, to fight tooth and nail. Prosecutors, on the other hand, swear to seek justice, not merely convictions. When those two fundamental duties collide in Spencer hearing, the courtroom truly becomes a moral circus. Critics argue that Florida gives judges too much power in these life and death situations, making them too much of a superior juror. So, whichever side the debate that you land on, remember this is a process initially adversarial. It ideals the truth and at least justice. Yeah. So today the defense threw every available mitigator they had into the record: brain scans, harrowing trauma history, mother's tears, even the claims of jailhouse altruism. The prosecution, in turn, powerfully reminded the court that 2 heartbeats stopped in a packed house, emphasizing the horrible loss. Under Florida law, the judge can choose life. He has that power, but he also can choose death. What do y'all think about this case so far? Hi. Ha 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 ha. I bet you are, boo. Oh, Lordy, y'all have mercy. Hello. So we're going to play this trial. Yes, I have it preloaded. Now now that I've gone through all of that, let's look at the trial and kind of see what you pick up, or the hearing, I should say. Depending on the speed in which they're talking will depend on how fast I play this. Okay, we got breaking news. Breaking news, y'all. Let me pull it up. Let me share this screen if it will play. I don't need the music. But I didn't ask for the ad. Why are we getting the wheel of death? I don't want the music. Okay, I will mute this. All right, fine. Dang it. Enough with the play. I am wanting. Why? Jen, what the hell is going on with this thing? It won't let me play. All right, let me do this. Less than 1 month before Brian Walsh was due to go on trial for red room and dismemberment of his wife, the judge ordered he go under mental health evaluation. The trial is postponed. Judge Bernier issued the order for a competency examination today. The case docket shows the court did not release a copy of her order. Of course not. The order cites state law that allows the court to order an examination. Quote, whenever a court is competent jurisdiction doubts whether the defendant is in a criminal case is competent to stand trial or is criminally responsible for the reason of mental illness or mental defect. Later Monday, a hearing was held and Brian Walsh was ordered to be sent to Bridgewater State Hospital for 20 days to determine whether he is competent to withstand trial. Oh, lovely! I used to work at a hospital that he's going to, not that one, but one just like it. The final pretrial hearing, which was scheduled for Tuesday, was rescheduled to another competency hearing set for October 27th. We got to get that on our calendar, June. If there's a question about whether he can do that, it makes the entire trial invalid or create an appellate issue. Even if he were to be convicted, there would be an appellate issue. He wasn't able to help himself during trial, explains the attorney Greg Henning. Brian Walsh's trial was previously scheduled to begin October 20th, but it is now being rescheduled. The court docket said he faces charges of red room misleading the police investigation and improper conveyance of a human body. And Anna Walsh, 39, the mother of 3, went missing on New Year's Day in 2023. Prosecutors believe Brian Walsh unalived and dismembered her before disposing of her remains. Defendant attorney Larry Tipton said that the court that Brian Walsh's mental and physical health has declined since the attack he was attacked in jail last month and is not well enough to participate in the preparation for trial. So this is what I have a problem with. I worked in a state hospital, y'all. I worked in a state hospital for the forensically insane and all of that jazz. All of that jazz. And let me tell you, it's interesting how inmates will go into jail sane and turn mentally incapable or insane just before trial. June, check messages here in StreamYard. So, yeah, pretty interesting and pretty convenient in my humble opinion. So they had a situation where he was attacked or part of a situation in jail about a month ago, and now you're sitting here telling me that he is incompetent, he is incapable because of that attack. I don't understand that. I don't. I have no understanding of that. I guess because of my history of working in the state hospital, I see this somewhat as a game sometimes. Now, sometimes it's legit, but more often it's not. So they're claiming that he was attacked in jail last month. And that would be let me see if I can read that. Approximately 9:55 p.m. on a certain date. An individual in custody at the Norfolk County Sheriff's and Denham was treated for non-life-threatening injuries after being assaulted inside one of the facility units. Walsh has been taken to Bethesda Medical Center in Boston later this year. The other not be named was subdued by officers and a makeshift blunt instrument was recovered. Oh, it was blunt. It wasn't sharp. So in the summer, a judge allowed a piece of evidence prosecutors to trial level. So that goes on about that. Okay, the defendant has made progress, but both mental and physical effects of violent assault have continued to prevent him from being able to actively participate in preparing for his defense. He made great efforts to do so, but at this time, it's evident that the trauma results from the unexplained and sudden attack continues to significantly his ability to work with his attorney in a manner required for his complex trial approaches. The competency hearing was one of several new elements added Monday. Others include series of responses to prosecution. All right, now we're going to get back to this. Well, okay, is that better? I don't know why my thing is off, but it is. Okay. So we're going to get back to the trial at hand. But yeah, no. I'm not believing you, Walsh. I'm just not. I'm sorry, not sorry, but let me get this back to where it needs to be. Sorry, not sorry, but Walsh, I don't believe you. Okay, now we're back over the Jose Soto-Escalera. We're going to look at Well, hearing from earlier today.
All right, we're on the record. All parties present. We have Esquire reporting here as well.
Do you see anybody in your waiting room?
And we do have people on the Zoom. They just haven't turned on the Zoom here. No, they have turned on there. You'll see them in a second.
You are in the meeting now.
Oh, congratulations. Thank you very much. Wonderful. This now.
All right, so I see the names of the people. I don't know if you see their names or you can see their pictures.
Yes, there's Dr. Schwartz.
All right, and so we're here for the Spencer hearing in the case of the state of Florida versus Jose Soto-Escalera. It's case number 18 CF 2614. And from the defense, any additional evidence for the court to consider in its decision-making process?
Yes, Judge, you'll see on the Zoom, we have Shari Schwartz, our mitigation specialist. She, I think, can offer a better insight into the history of Jose's family than his family. I think she may be a better historian of those facts. And we'd like to take some testimony from her on that issue. She has prepared a report, Judge. I only have the one copy, I think. No, we have an extra copy. We can give a copy to the court. I don't know if Ms. Schwartz will be reading it in its entirety, or whether we'll just go over it point by point.
Sure. State have a copy as well?
We do now.
Hello, love.
All right.
Hello.
So that's what we'll call it this time.
All right, so Ms. Schwartz, if you raise your right hand, I will swear you. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Burns, you may inquire.
Tell us who you are and what are your qualifications for the work that you do, Ms. Schwartz?
My name is Sherry Schwartz, and I have a PhD in psychology from Florida International University, and I work primarily as a mitigation and specialist sentencing advocacy, but I also do victim advocacy work as well, not on the same case.
And how long have you been so engaged?
Since 2010. I started with the Miami-Dade Public Defender's Office Capital Litigation Unit in January 2010, and then I went out on my own in January of 2014.
Is that when you founded Panther Advocacy and Litigation Sciences?
Correct.
And how long have you been involved in this case?
It's a little just shy of 2 years.
Where are you coming to us from right now?
I am in West Virginia working, not on vacation, or I would be in court. And
Very
I
good.
apologize for that.
No, that's fine. Do you have the report that you prepared with you?
I do. I just have it off to the side, unless you wanted me to read it, or did you just want to ask me questions? However you want to do it is fine.
I'll just ask you some questions, but I'm going to kind of run through it topic by topic. If you want to refer to
Okay.
it, go ahead. Just let us know if you're doing it.
Okay.
I first want to address the title. It's a biopsychosocial report. What exactly does that mean?
Right. So biopsychosocial considers the biological, or what I do is I investigate biological factors, psychological factors, and social environmental factors that may have impacted a criminal defendant throughout their life.
And where do you derive the information that gets you to form your conclusions and write a report such as you have done?
Mostly it comes from interviews of the defendant, but also any family members, any friends, coaches, teachers, anybody that knows the defendant or remembers the defendant from a long time ago, even if they haven't seen them in a long time. These are potential sources of information. Also records, things like jail records. If somebody has served a prison sentence previously, then I would request those sorts of records. So basically any kind of information, medical records that might yield some information on these biological, psychological, and social environmental factors.
So it's not overstating it to say that you're essentially trying to reconstruct, in this case, Jose's life from start to the present moment.
No, I don't think that's an overstatement, but certainly there's a focus on these particular factors that may be relevant to to why the person is in the situation that they're in today.
But you certainly cast a wide net as far as people that you might seek information from.
Correct.
Were you able to observe, whether on television or in person here in court, the testimony from Jose's family in the penalty phase?
I was in court, yes.
And those are all persons that you have met and conversed with before, yes?
Yes, we went to Connecticut and spoke with them.
Is there anything that you think is significant that did not come out in their testimony regarding Jose's prior history or family history that you would like the court to consider And you can refer to your report if you wish.
Okay, I'm not referring to it yet, but I may just look through to make sure I didn't miss anything, because I neglected to mention I'm also a college professor, yet somehow when I'm testifying, I get very nervous, so I apologize. So one of the things with Jose's mom, so if I take it in chronological order, Jose's mom was 14 years old when she met his dad, who was 20. Right. And so they were in Bridgeport, Connecticut. This is criminal behavior. It was criminal behavior back then on the part of Jose's dad. Mom winds up pregnant with a son that was not Jose. He had an older brother who only lived a few months. Dad, Concepcion Soto, when she got pregnant, they left the state of Connecticut. They went back to Puerto Rico. Well, not back, because she was always in Connecticut since she was a little girl, but he took her to Puerto Rico where his family was. She had the baby there, but they were in an area of Puerto Rico where there was no major hospital. She's a child herself. She has no car, no access to transportation, hardly any money, and the baby became sick. Dengue fever was an epidemic at that time, and that's what the baby contracted. And depending on who you ask, if you ask Jose's dad, he'll say that the baby was just sick and passed away. But of course, if from mom's side, he wouldn't take her and the baby to the hospital. His family was not very helpful, and the baby died at home in her arms. And by all accounts, she was very, very different after that. So she gives birth when she's 15. This happens when she's still 15. A few years later, she becomes pregnant with Jose. She's still young. She's 17. She gives birth to Jose at 18, and then makes her way back to Bridgeport, Connecticut.
With Jose?
With Jose, yes.
And he was just an infant at that time?
He was an infant, yes. Little less than a year.
And so did Concepcion, the father, return also to Connecticut?
He did at that time.
Did he stick around?
No, a short time after they separated, he was a bus driver in Connecticut. He didn't live very far. To hear him tell it, he had a wonderful relationship with Jose and Jose's younger sister. But the reality from multiple collateral interviews is quite different. It's that he was in town, but he was pretty much absentee. He had abandoned the family. So he was not somebody that the kids or Miss Carmen Escalera could count on.
And Concepcion had indicated to you earlier in the case his willingness to come and be a penalty phase witness. He backed out at the last moment. Is that correct?
Yes, and we got two different reports. He told one member of the family that he had contracted COVID. He told another member of the family that he had a stroke.
Okay, first of all, let's stop here. He didn't have to do anything. This is not a requirement. He's not subpoenaed to be there. And the penalty phase, it's voluntary. You don't have to legally, you're not required to be there. So, yeah, it doesn't surprise me if he wasn't there in the life of his child and he wasn't there in the raising of his child and he's been inconsistent. What would make you think that he'd be consistent now? Just my humble opinion.
What about alcohol or drug use in the family when Jose was growing up?
So Carmen, presumably to deal with the trauma of losing Jose's older brother and then having to be a single mom, and they came from meager means. There's no shame in that, but they really didn't have very much. And to deal with her pain, the trauma.
So she didn't have very much. She was poor as can be, but she found a way to purchase alcohol and drink her sorrows away. I have very little sympathy in this situation, and I'm trying very hard not to be so cynical. But at the same time, it's like people sitting here saying, I can't afford groceries. I can't afford to buy clothes for my children. My children are starving, but yet you have money to be an alcoholic. Boo.
Whatever was going on with her, she began to drink heavily. And this was noted by her family, her sisters, Jose's cousins that were in court. And so she didn't take care of the kids, Jose and his sister. They were living in the same building. The family all lived in the same building. It was a close-knit family in that regard. But Jose was raised or living in his aunt's homes in the building.
What was the source of income? Who was working what jobs? Do you know?
I don't know everything, and I honestly don't know if Dad paid any kind of support. I don't think that he did. You know, he may have provided something here or there, but I don't think he was on any sort of formal child support order.
Was Jose's family
But-
receiving public assistance?
Well, the housing that they were living in was definitely a housing project. So in that way, yes. But in terms of monthly checks, things like that, I don't know.
There is a part of your report called transgenerational trauma. What does that mean and how does it manifest in this case, please?
Well, so transgenerational trauma is something that the science supports, that it's passed down through the generations. So even though in this particular case, even though Jose was not yet born when his mother was a teenage mom, a very young teenage mom, and gave birth and then had the baby die at home, her trauma would pass down to him. And I'm not a biologist, I'm not that kind of scientist, so I don't want to overstep my area of expertise. But I will say, just from the psychological impacts of that science, it shows that this kind of trauma gets passed down biologically, that it actually has impacts on kids and their brain development, emotional development, and things that are, these would be a biological factor, but also a social environmental factor where, in this case, mom is having self-medicating and things like that.
Okay, in layman's term, he wasn't there when it happened, but mama is trauma and triggered, and her trigger and her trauma, she kind of, lack of a better term, takes it out or imposes on him, and he accepts that trauma subconsciously and takes it on himself, and now he himself is traumatized because of his mama's trauma. That's the way I understand it.
Now, the testimony that was before the jury was that Jose left Bridgeport, I think around age 15 or 16, to come to Florida. Is that supported by your research?
Yes, about that age. He was very young.
There is a section of your report entitled Jose's Resilience. Tell us about that.
Right. So resilience, there's a whole body of literature on that too. I'm talking about it from a psychological perspective. Resilience is our ability to manage situations and rebound and, come out on the other side okay. And so in Jose's case, throughout his life, he's had adversity, but he's managed to stay out of trouble as a kid living in an area where people did not stay out of trouble. It was a very dangerous, very high crime. There's government documents on that, as a matter of fact, that I was able to find and read through. And he managed to make his way to Florida, not on his own. He came with a girlfriend's family at that time. And to hear the aunts tell it, this was a good thing for him, because then this way he's now a teenage boy. He's getting out of ground zero for getting into gangs and things that are going on there, things that he had managed to avoid up to that point. And so he comes to Florida, and his life, even though he's young and he doesn't have parents, he's at work. He didn't have his parents here with him, I meant to say, but he has work, and he has always maintained a strong work history, always manual labor positions, because he didn't have an education, a higher level of education. But Jose is also someone that's very much tries to make the best of situations that are beyond his control.
There is a section in your report, I'll confess I have some trepidation in questioning you about it, but I think it's relevant. It acknowledges the victim, in this case, Tania and Josiah's loved ones, and they are identified as co-victims, correct?
Yes, that's correct.
And you develop a little bit, I don't know, I don't think it's your own work, maybe it is, but I think it's derived from studies. What can you tell us about the psychology of being a co-victim in this circumstance?
Well, it's not my science. You're correct. It's science that I'm citing. But I do have experience working with co-victims, particularly in homicide cases. And so what we know from the science, but also from practical experience, is that the court experience that is supposed to bring us as citizens, the truth and justice and vindication that we seek, right? If we're a victim of such a horrible crime like this. And what we find is that it actually has the opposite impact. The longer that someone is in contact, a co-victim, with the criminal justice system, the worse their mental health outcomes. So the more contact in court with prosecutors, with police officers, various things that happen around this process, and the longer that goes on, the lower the mental health functioning in terms of higher rates of depression, higher rates of anxiety, and a lot of trauma around that as well. So it's a system and a process that really, for lack of a better word, tortures victims, co-victims. I don't think that's the intent of the system, but it is the practical impact.
Right, thank you. Yes. In your work on the case in the past 2 years, you have conversed with and interacted with Jose?
Yes.
There's a section, I think it's toward the end of your report, entitled Empathy for the Victims, Authentic Empathy for the Victims. What can you tell us about that, please?
Early on, Jose, when I first got on the case, Jose had mentioned, just in conversation, getting to know him, getting to know the case, getting to know his relationship with Ms. Wise. And, this is many years after this happened. He had stated something along the lines of, this is not a direct quote because it was many years ago and I don't remember the exact words, but it was something along the lines of him feeling, I asked him to describe Tanya and he said, she was a nice person, that she didn't deserve this. And, that this was his child. He didn't know that at the time, of course, but finding that out hit him really hard. And that was unprompted. When I'm looking at those things, if I have to ask a defendant how they feel about it, and I do if they don't tell me, but in his case, I didn't really have to ask about that. And we never really talked about it again because we're talking about other things that are relevant to his biopsychosocial. And again, I guess it was a little more, it was before I wrote the report, as I was preparing the report. And, I was checking in on a legal visit because he had been in court. I wanted to, make sure he was okay after the death recommendation. And the first thing he said to me is, no one has asked me how I feel about what happened to Tanya and Josiah. So, these are the kinds of things that indicate genuine empathy. In that moment when he should be thinking about, or not that he should be, but that most people would be thinking about the consequences for themselves, he mentioned Ms. Wise and baby Josiah.
Now, we haven't touched on every single specific item in your report. The judge has it to consider, and I'm sure that he will. The last item in your report is titled an executive summary. So why don't you tie everything together in summary form for us now, if you can?
Sure. Can I just take a look at that so we make sure I don't miss anything?
Yeah, go ahead.
Okay. I promise I won't read it because it's kind of long. But basically, there are a number of biopsychosocial factors that are relevant to Jose and his life existence. And those things are things like adverse childhood experiences, right? He had exposure to parental abandonment, his father leaving, maternal neglect and alcohol abuse in the home, inconsistent caregiving, exposure to trauma. He witnessed himself extreme violence in Bridgeport, including shootings and gang activity, but he also has the intergenerational trauma. Growing up in poverty, I don't think that that's necessarily something that predisposes someone to committing crimes, but we do know that in high poverty areas, there are higher crime rates. And Jose managed to avoid that, which is really notable. The family also dealt with a lot of discrimination and racism in Bridgeport, Connecticut, when Jose was growing up and even when his mom was growing up. So this was kind of the social environment where they were living, but this is also a family who has really strong kinship bonds. And even if they don't see each other every day or talk to each other every day, they do, they show up, even if they were nervous, they weren't able to really articulate everything that they wanted to say, but they are generally very
June to private chat, StreamYard, thank you.
supportive of each other. And I think the authentic empathy is, to me, I don't always see that. I wish I could say that I did, but I don't. And in this case, it was really remarkable, especially the day after the death recommendation when Mr. Soto-Escalera, one of the first things that he said with a lot of emotion was that no one had asked him how he felt about what had happened to Miss Wise and baby Josiah.
Thank you very much, ma'am. That's all I have for you.
Any questions from the state?
No questions.
All right. Thank you, Dr. Schwartz. And
Thank you.
any additional evidence from the defense?
Judge, may we go off the record for a second? I just
Sure.
need to have a brief
Sure.
comment.
Absolutely.
Thank you,
We'll
Judge.
take a
Oh, here
brief
we go, y'all.
recess.
Y'all, pay attention. This is going to get good. We're going to talk about this.
Allow the defense to speak to their client.
This is going to get nasty, y'all. Warning. Warning. Can y'all hear this? June, if you're still listening. June, if you're still listening, please go to StreamYard chat. I have a question for you. Anybody hear my sound effects? I played some sound effects. Can you hear the heartbeat? Let me know if you can hear anything, because I am trying to get my Stream Deck back up and going.
Mr. Wise. Okay.
Hey, they
You may
weren't
make
too loud.
Right. But outside of argument.
Thank you, Ms. McGuire. Wow. Okay.
I do believe.
Okay.
My client would like to address.
Okay. He may make a statement either under oath or not under oath at his choosing, allocution.
Let me
or
know how
otherwise.
that was.
Okay. You may make a statement, Mr. Soto-Escalera, at this time. Go ahead.
Thank you, sir. I'm bringing to the courts to address it. I have a conflict of interest. So I was asking for your permission, if possible, if I can get him removed from my case, because I don't trust him.
Mr. Soto-Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already.
Y'all, do you understand what's going on here? Let me explain what's going on here. In the 11th hour, 59 minutes and 59 seconds, so to speak, Jose Escalera is requesting for a new attorney because he has a conflict of interest and he doesn't trust his attorney. I'm like, okay, so explain to me, please. Explain to me, please. What did your attorney do so bad? What did your attorney do so bad? Oh, okay, never mind. I got a warning, emergency warning. What did he do that was so bad? That is a conflict of interest. We're going to find out, but y'all, I've never seen this.
Done
Never have I seen this at this point.
his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So
You're screwed, boo.
from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto-Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and
the
that
horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
correct. And as I explained to my client, I am not qualified to be on the case by myself because I'm only second share qualified. So Mr. Wright is serving on the case to the duration.
Right, and just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest. And does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto-Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in the sentencing proceeding. You understand you have that right to do that. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness, and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about.
Y'all wait. Let's just say that the attorney is going to let his emotions out of the bag. Just wait and watch.
So you can understand what I'm trying to say, if you have the time.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And I would, as I'm required to do, I would defer to their professional decision in that regard.
I think enough, Judge. I'm going to lay all that on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding rigorous on the advice of your people. What he is referring to is a Zoom
Whoa,
recording.
whoa. We're going to slow this down because he's upset. He's talking fast. We're going to slow it down. We're going to back it up a little. Here we go.
Professional decision in that regard.
With Diane.
Enough, Judge. I'm going to lay all that on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding rigorous on the advice of your people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life. We had witnessed Lucinda Cook. This was done, I think, on a Tuesday when it was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit chatting as counsel do between themselves, waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in the case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto-Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bull crap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot on this issue.
Oh my Lord, y'all. This is what I do. What the hell happened? My apologies, y'all. I don't know what happened. It just went down, and that's weird. Let me share screen. Let me get it back up, y'all. It's all right there. That's what I love about StreamYard. I can go down. It stays up. Let's see if it does it again when I go over here and do what I was trying to do. That's a crash and burn, boo. You just crashed and burned, Escalera. Oh my gosh, that was insane. I want to replay that.
Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bull crap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot on this issue, at least.
In that regard, for Mr. Soto-Escalera's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly, and then indirect appeals, which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in, mitigation has been placed before me. So we're at that stage where I'm to consider that. Put differently, if Mr. Soto-Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, will be a proceeding in that regard. But to be fair to Mr. Burns's respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals,
Right.
that they get along, because once this
The lawyer just got his hand smacked. And you know what? The judge is saying, dude, we don't behave that way. Your feelings are valid, but we don't behave in that manner. We're professional. Why am I going in and out, or is it my ears? We're professionals. We don't do this. But it was so good.
case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto-Escalera wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject. Okay. Okay. All right. So it's not the first time I've had to tell the defendant or someone else, that's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really, regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?
No evidence, sir.
All right, so let's start off with the argument of the state. If you wish to make a summary argument, but you don't have to. I mean, obviously, I'm familiar with my role here. I want to dissuade you from that, but you do both have the right to make argument to influence me in the way I evaluate the evidence,
Sure.
the way the aggravation and mitigation.
Yes, sir. I would just say that based on the extensive evidence that was adduced in the trial and the penalty phase, based on the aggravated factor findings of the jury, as well as the verdicts of the jury as a whole, the state request that the court imposed 2 death sentences in this case on both counts.
Thank you. And the defense, Mr. Burns.
Yes, I do have a few comments to make, Judge, in the nature of argument, some of them addressing aggravators and some just in general. Well, one of the things that needs to be considered and proved is that there was heightened premeditation in this case. I think certainly there was evidence that this case was planned and thought about at least for some days before the actual killing occurred. I don't know how extensive or how important the court would consider the testimony of the witness who indicated that Jose was interested in ghost guns, I think a couple of weeks before the killing. I don't know whether that manifests as an expression of an intent to do anything wrong. This was not a shooting or a gun crime. It did not arouse in the witness's mind at the time that there was anything nefarious going on. He thought that Jose might have been building a gun for sale. And so what we have here, the evidence in the case was that this was a pregnancy of many months duration that Jose objected to from the start, and yet there was no evidence of any kind of intent to do anything wrong until only a few days before the actual event. And so I would ask the court to consider that. On this next issue, again, I don't like to tread here, but these are just unsavory matters to begin with. Regarding the aggravator of child under 12, I certainly do not dispute that that aggravator is correctly found. I do offer for the court's consideration that the manifestation of that aggravator in this case is as mild as could be. I don't want to state it any more bluntly than that, but what we lost here and what we mourn here in Josiah, we lose and mourn speculatively. There's no personality that has been evinced. And so I think that although that aggravator is properly found, it could be even more horrible. We have testimony from Raul Benasco relative to the court imposing a life sentence without the possibility of parole, which is what I'm asking for in regards to each victim. That Jose's been fined while he's been incarcerated for many years in a county jail, which is not designed for long-term incarceration. He would be a good prisoner. He has skills to offer. They work them hard in prison. Jose has skills to offer. I also want to ask the court to consider that the nature of persons who ought to be executed should be such that Jose doesn't really fit the category. He has no prior criminal history whatsoever. This is a dramatic departure from nothing to a very horrible crime, but it is a crime of personal circumstances. It is not a crime of randomness. It is not a crime against strangers. It is not a crime where Jose indicates that he is some kind of danger to the community at large. It is a very particularized type of crime. Again, wildly at odds with his nature that we heard from his family and that we heard from Dr. Schwartz, and that is evidenced in his lack of a criminal record, which I think is really quite astounding. And finally, I think I would be remiss if I did not remind the court that although the recommendation is for death, it was as close a call as could be possible, and I would ask the court to consider that also in leaning towards life without possibility of parole for both counts. Thank you.
Thank you. Any response by the state?
No, sir.
Oh,
In abundance of caution, let me ask a question to the state, and in part, this is just to avoid the appearance of us as with regard to the evidence that we glossed over anything. I have my own view of the evidence, and I certainly listened closely. I don't know that this was really fleshed out in argument before the jury, but with regard to the cold calculated, premeditated, aggravating factor, which was found by the jury beyond a reasonable doubt, is my perception of the evidence correct from the state's view in that it does appear that there was substantial planning fitting the definition? However, there was a variance between a lot of the planning and the actual way that the crime was committed, in the sense that there was a lot of talk of a gun. And then,
Okay, one, why is his associate counsel, not the lead counsel, nodding her head and going off when that is a no-no? Boo. You cannot react that way in court, whether you agree or disagree. You've got more learning to do, my love.
the murder occurred by different means, and which doesn't undo the aggravating factor, but it's something I because I've never heard the state directly address that. I don't think the state directly addressed that with the jury, because it's kind of an aside, but just to cover every base, and because it was brought up by the defense, what is the state's view of the situation there with the evidence?
Yes, so the evidence, the way the evidence shook out was that there was a significant degree of planning in the days leading up to this, particularly beginning on August 21st of 2018. The defendant discussed using a firearm on multiple occasions.
You address that with the jury, because it's kind of an aside, but just to cover every base, and because it was brought up by the defense, what is the state's view of the situation there with the evidence?
Yes, so the evidence, the way the evidence shook out was that there was a significant degree of planning in the days leading up to this, particularly beginning on August 21st of 2018. The defendant discussed using a firearm on multiple occasions, but the court is correct. At no time did the defendant ever discuss cutting her throat or hitting her in the head with a large blunt object, which was the ultimate cause of death in the case. So although there was much discussion, and I think he did go back and forth on the way he would kill her, I don't recall any specific statement regarding either cutting her throat or hitting her in the head with a large blunt object. He also did discuss using a second person, presumably a Alvarado. But again, there's no evidence that was actually carried out.
And there was discussion, I have this in my notes, but just an abundance of caution. There was discussion between the defendant and Mr. Alvarado in the garbage truck about the location of where the crime would occur.
Yes.
The route, the garbage route.
Yeah, in several different conversations.
Right.
Yes, sir.
All right. Well, particularly given what was brought up with regard to counsel and so forth, I do want to commend the attorneys for their fine work. And no one can do that better than me because it's right now squarely before me. Let me tell you where I am in the case. This is one of those situations where, as a judge, you could try to put the case out of your mind as much as possible. But I found doing this that even when you think you're doing that, you're still thinking of this case. And I've been constantly thinking about it.
So the case is under his skin.
I'm far along in my analytical process. However, more has been put before me today, particularly fleshing out other suggested mitigation and a few others that are also new suggested mitigation. So I have that to shore up, but I do intend to finalize my decision and announce my decision this Friday, which is the 10th at 1:30. There's a chance that I'm not done by then, but I think I will be done by then. There again, I'm far along, and I appreciate the doctor's report. I will review it in exquisite detail and dissect it along with my notes to make the final decision in this case. Either way, the decision of the court must be in writing. So I will announce the decision on Friday at 1:30, and we'll see you then.
Yes, sir.
Thank
Thank
you.
you, Your Honor.
Go off the record. In the
Okay, there we go. We have his sentencing at 1:30 their time, 12:30 my time. I am making sure it is on our calendar and ready to go. There we go. And we are done with the hearing. Oh my gosh, y'all. What a hearing that was. Oh my Lord, y'all. Quite a bit of a bombshell that Mr. Escalera threw at his attorney and at the judge, pretty much demanding a new attorney in the 11th hour, 59 minutes and 59 seconds into his entire situation. It's interesting that the mitigating factors that I spoke about before we watched the video came into play concerning the family drama and the situation with the mother and her life before having him, and how that trauma has been kind of inherently put on him. I find it difficult. If I was on a jury and had to decide this, he would get DP, because I first of all, to sit there and tell me this man has an IQ of an IQ of 72, which is borderline, I don't agree with that at all. I really, really don't. Not in the least. He planned this. He forethought this. This was not something, it was not a crime of passion. He knew he was going to do it. Then he poured bleach over the body. He wiped down the casings. And the doctor's sitting there saying, well, it's like the kid hiding the cookies. No, it is not. You're getting paid to do what you do, and I respect that, but I don't respect your opinion on this. And I can. It's my humble opinion. And in my humble opinion, he's guilty as hell, needs to fry. And I don't mean by, getting sunburnt, in my humble opinion. When you unalive your girlfriend who is pregnant 8.5 months along with your child, and should she have given birth naturally or under emergency C-section, that child is considered full term and would survive unless there's some other medical complications. Otherwise, I don't get it, and I'm not happy. I'm not. Yeah, that's how I feel. I have a whole lot of other ones I could throw at you, but yeah, the BS meter is getting pretty high there. So I want to say thank you, everybody, for joining. Tomorrow we will be live again. I have to figure out what I'm going to do tomorrow. We do have some stuff coming up tomorrow. What's my calendar say? I came in straight from Austin and sat down and did this. I have nothing on my calendar for tomorrow, but I know we have something tomorrow, so we'll get it on there. So Soto-Escalera finishing his sentencing on the 10th. On the 13th, we have Sheldon Herring Jr. and Columbus Day. Mods, we have our meeting on the 12th. We postponed it. And then on the 20th, Brian Walsh has been postponed. I'm slipping him, I think, they said something about the 27th, but on the 20th, I don't have a date for that postponement yet, so I'm going to remove him from our calendar. Oh, darn. So we're going to be doing some rewatches. We're going to be doing some old cases. We're going to be doing all kinds of stuff to fill in the gaps between these major trials. So if there's nothing else, you guys, thank you so much for joining me tonight. I hope y'all have a fabulous rest of your evening. I will see you guys tomorrow. Make sure you have our bell clicked to make sure you have the likey likes. Do become members if you haven't already. We had a members only live. I gave away some merch yesterday. So yeah, been a good day. I kind of miss being live with you today, but I got some things done. I've got a lot of unpacking to do because we moved a whole business that we had to move out of a business building into my home. Have a great evening, Miss McGuire. I hope you come back and see us again. We greatly appreciated having you today and having you in comments. Once again, you are a blessing, and thank you so very, very much. In the meantime, everybody, y'all have a fabulous evening. Get some sweet sleep, and we'll see you here tomorrow. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.